Okay, we'll wait here for your judge and then we'll get started. Your judge is having a little bit of a problem. We're hopefully going to get them in the courtroom soon.
No, 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 no. Mr. Werner, can you see me or hear me?
I can hear you, Your Honor.
I'm sorry, yes to both?
I can see you and hear you, yes.
I can't see anyone. I apologize. I am working off of a really bad computer this afternoon. Anytime I try and click on the view, are you still there?
I can hear you. I can see you. It's all working fine from this end.
I can't see our courtroom. All I can see is the original competition schedule courtroom. I don't see.
Is there another window perhaps it's been buried under or something like that?
That's what I'm wondering. That looks better, I think. My apologies, everyone. No, I don't want to cancel. Well, how far had we gotten? Had the teams announced their codes yet? No?
No, Your Honor, we have not.
Is that our Zoom host? I desperately need help.
I think that's your lead defense attorney that was just speaking.
Okay. I need a high schooler in the court with me, stat. Literally, I'm sorry. Whoever our Zoom host is that is helping, this is Judge Billings Bella. We run on WebEx in our virtual courts. I cannot see my screen, so I really could use some assistance if you have audio to help me. Well,
another application open? Sorry, I'm one of the student attorneys. Is there another application window?
Well, as a matter of fact, there is, because I thought we were instructed to have a window with our score sheet and a window for our virtual courtroom. Maybe I'm wrong about that. But let's try now.
So, Your Honor, this is Matt Werner. I think unless you have two screens, it's going to be hard to have this. You do. Can you put the scoring on one and it's still not working?
Well, no, I think I'm good. I was caught in this little tiny window, but sorry. Well, let's see how far we can get, because we need to fill in our score sheets, and I think we would do that once we ask each side to introduce themselves. So is the plaintiff ready? And if you would tell me your team code, please. Maybe I'm doing this wrong.
Yes, Your Honor. Team number 3?
Team 3, all right. And is the defense ready? And your team code, please.
Yes, Your Honor, the defense is ready and we are team code 6.
And I apologize, you are the guinea pigs for our first Zoom mock trial session. I assure you things will go smoother for everyone in future rounds. I'm going to just ask, beginning with the plaintiff, we need to enter into our score sheets, plaintiff's counsel, 1, 2, 3, then plaintiff witnesses, 1, 2, 3. So however you all have been instructed to give us that information, beginning with the plaintiff, I would appreciate it.
Your Honor, would you like us to submit our rosters into the Zoom chat function?
Sure. Okay, there is a chat feature. That would probably be helpful. So you're just going to, plaintiff is going to list counsel 1, 2, 3, witnesses 1, 2, 3. Then we'll ask the defense to do the same after you see those screens populated for plaintiff. Thank you. If you were trying to give me a screenshot of the names, I'm not able to open it.
Good afternoon, Your Honor. My name is Isabella Cuna, and I'm the lead lawyer on prosecution.
All right, I think that's going to have to work. I'm sorry. I'm on a state issue computer, and it doesn't have a lot of files. So I'm putting you in as Plaintiff Counsel 1, Ms. Cuna, thank you. Plaintiff Counsel 2? So I can see Ms. Lily Burdick. I assume that is you speaking, but my computer's telling me your bandwidth is low and I can't hear you. I'm very sorry. If our Zoom host can be of any assistance, I'd sure appreciate it. While maybe Ms. Burdick can look at her bandwidth. How about Plaintiff Counsel 3? Who's that, please?
Hello, Your Honor. My name is Chase Kloss, and I am Plaintiff Counsel number 3, and
Thank you. How about Plaintiff Witness number 1?
Good afternoon, Your Honor. My name is Caitlin McCready, and today I am Alex Cifuentes.
Thank you. And Plaintiff Witness 2?
Good afternoon, Your Honor, members of the jury, opposing counsel. My name is Isabella Schulte, and I am Kyle Kuzak.
So you're not showing up there for me. I heard Isabella.
Isabella Schulte, and I am Kyle Kuzak.
Oh, there you go. Okay, thank you.
Right.
And gosh, I don't know if it's on my end that I'm having a hard time seeing and hearing people, or if it's on
Your Honor?
your end. Mr. Werner, is that you?
Are you able to see everybody? Yes, it is me. Are you able to see everybody?
I can see them as they come up, but I can't.
Can you see a little box on the top corner of the little box that's on your screen? And I think if you click that box, it'll maximize it out and you'll be able to see everybody at the same time, perhaps.
So for gallery view. All right, very good. How about plaintiff's witness 3.
Good afternoon, Your Honor. My name is Daisy, and I am Jordan Markowitz.
All right. Thank you. And for the defense, I think if that's in order in the chat feature, I'm able to read that. Is that in order? Jaden Inks is the first attorney name, correct, counsel?
Yes, Your Honor.
All right. And then counsel 2 for the defense, Brendan Mayer.
Yes, Your Honor.
Thank you. And defense counsel 3. There. William, help me pronounce your last name correctly, sir. William.
It's Damon, Your Honor.
Damon. Very good. Thank you. And for the defense, witness number 1. I think I see Blake Van Owen. And defense 2, Taylor Perkins. And defense 3, Avery Becker. All right. We've been instructed, and I've used up too much of your time trying to learn Zoom here, to take recesses, but there is an exception. If anyone has any health emergency, please let me know about that. I expect a Zoom chat feature might be the best. Otherwise, we just hope to keep going through. Now that we've had a chance to populate your scoring sheets, do any of our scoring panelists see any conflicts?
This is Matt Warner. No, Your Honor.
And Mr. Harwood, any conflicts?
No, I do not have any conflicts.
Okay. Do any of our team members see any conflicts that we may not be aware of?
No, Your Honor.
All right. Thank you. Somehow, now that we've checked our conflicts, oh, sorry, if that was Ms. Burdick again, I don't know if that's just on my end that I can't hear you or not. Would one of the timekeepers, I'm not sure who's supposed to notify, or we're waiting for the all go, I think, from the director. Let's just soldier on, and hopefully I'm going to get an alert at some point. Thank you, Ms. Burdick. Sorry, I am empathetic about this computer difficulty that you're all having, or you're having, and I'm having along here with you. All right. So I'm going to go ahead, and I assume we've got a YouTube audience of coaches, family members, friends. So we're just going to go through all of us and take the oath of the mock trial competition. Team members, please raise your right hands. Do you promise that the presentation you're about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Thank you. Witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your Honor.
Yes. Thank you. Gallery members, including teachers, attorney coaches, family members, and friends, as you raise your right hands, do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? And scoring panelists, as you raise your right hands, do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
I do.
Thank you, gentlemen. I'm going to wait and get the go-ahead from Ms. Burdick that she's been able to get a new laptop, and I am waiting to hear from our judging room that we have the all go. I don't know if the timekeepers get that or if I'm going to get that directly. Mr. Werner, do you know if we heard that in our orientation?
I can call Mr. Downey and ask him that question, Your Honor.
Appreciate it. Thank you.
Your Honor, this is Dick Harwood, one of the panelists.
Thank you, Mr. Harwood.
May I ask what the team codes are? I was signing on and I think I missed those.
No, thank you, sir. The plaintiffs, you'll correct me if I'm wrong. I have you as Team 3.
That is correct.
And for the defense, Team 6.
Thank you very much.
And you got everyone's names, Mr. Harwood?
I did not, but I will get those later.
Can I, you'll see the defense attorneys and witnesses are in order. Perhaps the screenshot didn't work for me for the plaintiffs. Could I ask a member of our plaintiffs team to just type into the chat feature the names of your first, 1, 2, 3 attorneys, then 1, 2, 3 witnesses? I don't know if Mr. Harwood can download the screenshot that you uploaded, or I'd ask you to put that in there. Thank you. Ms. Burdick, let's give your new laptop a test. Would you state your name, please?
Yes, I'm Lily Burdick. Can you hear me?
There you go. That's working much better. Thank you.
And Your Honor, Mr. Downey says we can go.
Okay, thank you. Timekeepers, I assume you are ready because I can see identified timekeepers on my screen. We are going to begin with opening statements, first by the prosecution and then the defense, 5 minutes each. I've been asked if you are a non-participating member, it looks like you already knew the instructions, to mute yourself, turn off your video to try and save some bandwidth. So, counsel, when you're ready.
Your Honor, one moment. We have some preliminary matters to.
Thank you, Ms. Kuna. My apologies for neglecting to ask if there were any pretrial matters for the prosecution.
Yes, Your Honor. Prosecution would like to verify that the judge and jury have a notebook or packet with the case exhibits.
We have access to it. Yes. I don't have anything you've marked. So to the extent that counsel was told we would know how you're marking your exhibits, we don't. So we'll just do our best.
All right. The prosecution would like to enter stipulated facts.
Thank you.
And prosecution would like to inform the court that rosters have been electronically submitted.
Thank you.
Prosecution requests that time will be stopped for any technical difficulties.
Brilliant idea. Thank you. Yes.
Prosecution requests that exhibits are not screen shared until entered, and that the witness refers to their trial notebook to keep the jury from seeing the exhibit until it is entered.
Any objection from the defense on that?
I believe that that works.
Okay, thank you, counsel. Any other pretrial matters, Ms. Kuna?
Yes, Your Honor. Prosecution requests that any time remaining after the closing argument be saved for a rebuttal.
So ordered.
Thank you, Your Honor.
Any pretrial matters from the defense?
Yes, Your Honor. On behalf of both teams, Your Honor, we request the court's preference on redirects and recrosses.
You will ask if you wish to redirect. Is that what you meant?
Just whether will the judge allow redirects or?
Oh,
or
I apologize. I will. So I will allow redirect. Recross technically is very narrowly limited to those precise matters that came out in redirect. So council, just be prepared to address that if that becomes a contested matter to address on an objection.
And then pursuant to Rule 7.4 for document sharing, I forgot about this when you asked of objections. We ask that when an exhibit is shown to a witness, a member of the examining attorney's team shall make the document available to all participants via screen sharing or similar technology. And that is Rule 7.4 in the rulebook of mock trial.
And Ms. Kuna, I assume you all have kind of worked through that?
Well, we were hoping that the exhibits would not be shared until after entered, so that the jury would not see them until entered.
And perhaps I didn't understand the motion being made by Ms. Inks. I'm just looking, so how is counsel going to show their witness the proposed exhibit? You're going to do that without screen sharing to the entire courtroom, and then that only happens if the exhibit is admitted?
So pursuant to Rule 7.4 in the mock trial competition rules, when an exhibit is shown, the attorney should share it with all participants. And then additionally, exhibits or other documents posted in this manner will not be deemed to have been shown to the jury unless they are admitted into evidence and formally published. So it's not a matter of the jury seeing them. It's a matter of they're not to be acknowledged as shown to the jury until they are admitted into evidence and formally published.
All right. So in order for, I think, our scoring panelists in the court to be able to follow along, there's going to be screen sharing of the exhibits. Correct me if I'm wrong, I apologize. We didn't do any advanced training on this so that we know what you're talking about for scoring purposes, but ultimately we know that exhibits or other documents are not admitted or you still have to move for their formal admission, and then, no, I'm sorry, I'm not following you at all. So there's a dispute about whether or not we, meaning the people on the screen, can see the exhibit before it's admitted? How is the court supposed to be able to rule on admissibility without screen sharing?
Your Honor, would you like me to pull up the rules and screen share them?
I've got the rule right here.
Okay.
I'm just trying to make sense of it. I apologize. If we were in a courtroom, I would have a chance to see the exhibit if there's a dispute about whether or not it's going to be admitted or not. And so somehow I have to be able to see it, but I'm hearing Ms. Kuna say you don't think there should be screen sharing until the exhibit's been admitted?
Yes, but we can do it the other way as well, if that's what is in the rules.
So we're all reading 7.4 together. Attorney identifies the exhibit they wish to show the witness and requests the court's permission for the witness to view it. I assume the only way they can view it is through a screen share. I could be wrong. Of course, we need to make sure that opposing counsel has seen the exhibit. Then the attorney is saying words to the effect of, I now show you what has been marked for identification as exhibit blank. Will you identify it, please? Witness should answer to identify only. Then when an exhibit is shown to a witness, okay, now here we're talking about documents are available to all participants via screen sharing or similar technology. The member of the team responsible for posting the exhibit must be a team member competing in the round or a timekeeper. Exhibits or other documents posted in this manner will be deemed not to have been shown to the jury unless they are admitted into evidence and formally published to the jury. All right, so as far as the pretrial matter, whether or not there's going to be screen sharing when we go through showing the exhibit to the witness, foundation, admissibility, they will be screen shared, but counsel still has to remember to go through that formal request to admit the exhibit. Is that everyone's understanding of how 7-4 is working?
Yes, Your Honor.
Okay.
Your Honor.
Thank you. Ms. Inks, other pretrial matters?
We request that our timekeepers be allowed to post remaining time in the chat throughout the trial so that we know what our timing is like, since we don't have time cards available.
That seems beneficial to everyone. Any objection, Ms. Kuna?
No objection, Your Honor.
Thank you.
And with that, there's no further preliminary matters, Your Honor.
Okay. And then Mr. Harwood, hopefully you've been able to see the attorneys and witnesses for the prosecution posted in the chat feature. Have you been able to populate your scoring sheet?
Yes, I have. Thank you.
Okay. Thank you. Thank you, everyone, so much for your patience. All right, now, assuming timekeepers are ready, we're going to begin with opening statements. First, for the prosecution.
Yes, Your Honor. All right. Good afternoon, Your Honor, ladies and gentlemen of the jury, co-counsel, and opposing counsel. Today, we bring forth the murder of Mackenzie Brackman. Hello, my name is Isabella Kuna, and I'm here today to unmask the truth about the murder of Mackenzie Brackman by Avery Becker's hand. Today, the prosecution holds the burden of proof to prove beyond a reasonable doubt that the defendant, Avery Becker, committed second-degree burglary of Mackenzie Brackman's home and the first-degree murder of Mackenzie Brackman himself. In order to meet these charges, the defendant would have had to enter Mr. Brackman's home without his knowledge or consent with the intent of committing a crime. Within this burglary, he would have had to murder Mr. Brackman, making it first-degree murder. The defendant, Avery Becker, was a star on the mock trial team at Colorado High School. The defendant was on the team with their friend, Taylor Perkins, and their other friend, Alex Cifuentes. The defendant was very unprepared when it came to mock trial. So, the victim, Mackenzie Brackman, moved the defendant from A team to B team. This lasted until the defendant's best friend, Taylor Perkins, quit the mock trial team altogether so that Mackenzie Brackman would have to move the defendant back up to A team in order to fill the spot. This lasted a couple of weeks until the defendant received some criticism from the victim, got angry, stormed out with a permanent marker in hand, and wrote Worst Attorney Award on the victim's car. This caused Mackenzie Brackman to kick the defendant off of the mock trial team permanently. After this, the defendant and their best friend, Taylor Perkins, went to the Fry Shack where they ran into some of the other mock trial members. Later that day, the defendant texted their friend, Alex Cifuentes, for help to get back onto the mock trial team. When Alex Cifuentes said that she did not believe that Mackenzie Brackman would allow the defendant back onto the team, the defendant got angry and said that they were going to trash Brackman's home. The next day, March 6, 2020, the defendant, Avery Becker, skipped school, broke into Mackenzie Brackman's home, and killed him. Today, the prosecution will bring forward 3 witnesses. Alex Cifuentes, a friend of Avery Becker, Kyle Kuzak, and Detective Jordan Markowitz. First, we will bring forward Alex Cifuentes, a friend and teammate of the defendant who received some text messages from the defendant about Mackenzie Brackman. Next, we will bring forward Kyle Kuzak, a crime scene reconstruction investigator. She will testify to the fact of the case which led her to believe that this murder was a burglary gone very wrong. Finally, we will bring forward Detective Jordan Markowitz, an accomplished homicide detective certified in cell phone data recovery. She will testify to the fact of the case which led her to the defendant as the only reasonable suspect. Today, the prosecution holds the burden of proof to prove beyond a reasonable doubt that the defendant, Avery Becker, committed second-degree burglary of Mackenzie Brackman's home and the first-degree murder of Mackenzie Brackman himself. Today, the prosecution will ask you to find the defendant, Avery Becker, guilty of second-degree burglary of Mackenzie Brackman's home and first-degree murder of the well-respected and attorney and mock trial coach, Mackenzie Brackman. Thank you.
Thank you, counsel. Opening statement for the defense.
Yes, Your Honor. Your Honor, opposing counsel, and members of the jury. My name is Jaden Inks, and my co-counsel and I are here today on behalf of our client, the defendant, Avery Becker. What is right is often forgotten by what is convenient. Today's case is about a tragedy. As you heard in the prosecution's opening statement, a well-loved coach and well-respected attorney, Mackenzie Brackman, was found dead in his home on March 6, 2020 at 444 South Flower Street. We agree with the prosecution on these facts. However, it is where we disagree that brings us here today. In the investigation done by the police, our client, Avery Becker, was found to be accused of killing her own mock trial coach, Mackenzie Brackman. Ms. Becker has been charged with first-degree murder and second-degree burglary of a dwelling. These charges prove the prosecution trying to make a conviction on Avery Becker of what was based on a convenience, not what was based on what was right. Avery Becker joined mock trial her freshman year and was looking forward to competing her senior year on the team. Avery excelled at mock trial and was excited to potentially win awards at her state competition and regional competition. Although she had excelled at mock trial and had done her best to prove herself, her and her coach, Mr. Brackman, frequently disagreed about Avery's preparation for competition. At the regional competition in early 2020, Avery won the awards of Best Attorney and Best Closing Statement. However, instead of congratulating her, her coach criticized her. Throughout her years of competing on the team, Avery showed her natural ability to exceed at mock trial through winning awards for best closing arguments and giving killer cross-examinations. So she was upset when her coach criticized her. And reasonably upset, she stormed out of practice and in the parking lot made an impulsive decision. She wrote across the top of her coach's car, Worst Attorney Award, and what she thought was an erasable marker. It was permanent. And after seeing this, her coach, Mackenzie Brackman, kicked her off the team permanently. After realizing the mistake that she had just made, Avery tried to apologize, but her coach never responded. The events leading up to this trial today are filled with many holes that the prosecution will not be able to fill. Their police work has shown to prove missing evidence or missing photos, questionable evidence, and work done by detectives that was rushed and sloppy. The choice that the prosecution has made in accusing Avery Becker of first-degree murder in the first degree and second degree burglary of a dwelling was a convenient choice, not the right choice. The defense will introduce 3 witnesses who will not only show you that Avery Becker did not commit this crime, but will show you how the prosecution's police investigation has holes and was missing evidence, and how that their choice was the convenient choice, not the right choice. First, you will meet Professor Blake Van Owen, who will attest to her knowledge in crime scene reconstruction and police procedures. And using her knowledge, she will testify to her expertise and her own theory of the case in police procedures, crime scene reconstruction, and cell phone data analysis. She will also shine light on an alternate suspect. Professor Van Owen found many discrepancies within the prosecution's case, especially their 2 witnesses, Kyle Kuzak and Jordan Markowitz. You will then hear from Taylor Perkins, Avery's best friend, who will shed light on Avery's alibi for the day. Then you will hear from the defendant herself, Avery Becker, who will tell you that she is sorry, she is remorseful for the action she's committed, and that she did not commit this crime. Today, the prosecution bears the burden of proof, and they must prove beyond a reasonable doubt that Avery Becker did commit these crimes. Today, the defense asks you, the jury, to return the verdict not guilty in the charges of first-degree murder and second-degree burglary of a dwelling, because Avery Becker was the convenient suspect, not the right one. Thank you.
Thank you, counsel. Prosecution may call your first witness.
Prosecution calls Alex Cifuentes to the stand, Your Honor.
And I apologize, I think I neglected to make the record that all witnesses are presumed sworn in. Thank you. Please proceed, counsel.
Right. Good afternoon, Ms. Cifuentes.
Good afternoon.
Please state your full name and spell your last for the record.
Alex Cifuentes, Sifuentes.
Thank you. And Ms. Cifuentes, why are you here today?
It was a killing of my beloved mock trial coach, Mackenzie Brackman.
How do you know the defendant, Avery Becker?
We were on the Colorado High School mock trial team together.
And were you friends?
I would say we were fairly good friends.
Is the defendant in the courtroom today?
Yes.
Could you please identify the defendant?
She has black hair and is wearing a collared shirt.
And let the record reflect that Alex Cifuentes has correctly identified the defendant, Avery Becker.
Good job.
How did you know the victim, Mackenzie Brackman?
He was my mock trial coach.
What were your interactions with the defendant at mock trial practice?
Avery was always late and it was super annoying.
And you knew Mr. Brackman. What type of coach was he?
Mr. Brackman was an amazing coach. He definitely knew what he was talking about, and he was super communicative and was always helpful as a teacher.
And you identified the defendant. Can you go more into detail about your relationship?
Well, we were friends in mock trial, but I never really saw her because she was always late. It was annoying to the whole team, but it looked really annoying to Mr. Brackman.
And at practice, what did you observe?
Well, Avery was always unprepared and didn't really know what was going on, especially because they were always late. They didn't really know what was going on. They were always late, never did any of the work. It was really annoying to everyone.
And what was the defendant's reaction after being demoted to B team?
Well, Avery was super upset. Her face turned super red. It was not that fun, but she convinced Taylor Perkins to quit the team so she could move back up to A team.
And what was the team like after the defendant got moved to B team?
On A team, everything was way more chill. Everyone just felt better about it because we knew we didn't have to cover Avery's slack, and we were super prepared.
Objection, Your Honor. Speculation.
Response?
The witness is just stating what she observed during practices.
Any other argument, counsel?
No, Your Honor. I stand by my
Thank
objection.
you. The objection's overruled. You may continue.
Thank you. And what was the environment like on A team after the defendant got moved back up to A team?
The whole team was stressed. The room had completely changed. We all had to cover Avery's slack and get more stuff that we shouldn't have to prepare for because it's her job.
What happened next?
Well, after regionals, Mr. Brackman kicked Avery off the team, like completely. Avery had pulled a prank on Mr. Brackman and wrote all over his car.
And what happened after the defendant wrote on the car?
Well, I got some alarming text messages from Avery that were talking about how she wanted me to talk to Mr. Brackman about letting her back on the team.
Permission to screen share Exhibit 14?
You may.
One second. We're having our co-counsel screen share, so it is taking a second. All right, thank you. Ms. Cifuentes, without going into the contents of this, what is it?
These are text messages between Avery Becker and I.
Is this a fair and accurate representation of the text messages you received?
Yes, 100%.
Has it been tampered in any way?
No, these are the exact text messages I received.
At this time, prosecution would like to enter Exhibit 14 into evidence.
Defense?
Your Honor, I object to this document being entered in under hearsay and best evidence.
Prosecution, response?
Your Honor, these are the text messages the witness received from Avery Becker. These were on the defendant's phone, or the witness's phone.
Response, if I may, Your Honor.
Yes.
I believe that is not a hearsay objection, that it was just that what the witness had received from another person. Therefore, it leans towards hearsay as well as best evidence.
Thank you, counsel. The objection is overruled. Exhibit 14 is admitted.
Permission to publish to the jury, Your Honor?
You may.
All right, co-counsel, you can stop screen sharing. Ms. Cifuentes, what did you find alarming about these text messages?
What I find alarming about these text messages is at first Avery is talking about how she wants me to talk to Mr. Brackman, but as we get further down into the text messages, she goes on about breaking into his house. I find that action very alarming.
All right, thank you. No further questions.
Cross-examination?
Yes, Your Honor. Ms. Cifuentes, you know Ms. Becker?
Yes.
And you two have always been really good friends.
I would say fairly good, not really good.
The two of you have been on the same mock trial team since freshman year.
Yes.
You saw Avery as an equal.
Yes.
Yet you considered yourself to work harder than her.
I would say I had to work harder.
You even admit to being upset at her when she won and was unprepared.
Yes.
You saw Avery winning awards at competitions.
Yes.
And this upset you.
When you're unprepared and you're still winning, it would be upsetting to everyone.
Because it should be you who's winning the awards.
She won.
In fact, there were multiple instances where you were jealous of Avery's success.
I wouldn't say jealous.
And thought that she was lazy and not a hard worker.
Yes.
You were present when Avery vandalized Mackenzie Brackman's car?
That is correct.
This incident resulted in Avery being permanently kicked off the team.
Yes.
And Avery's punishment put your team in a really hard place.
It did.
Many of you were very upset at her.
I can't speak for everyone else, but personally, I was quite frustrated.
There was even rumor that you and Avery were rivals.
I cannot speak on a rumor.
But you wholeheartedly disagree with this statement.
That Avery and I are rivals.
Yes.
Everyone on the team is a rival.
You spent a lot of time honing your craft.
Yes.
And you were upset when Avery came in and won all the awards without doing anything.
I wouldn't say upset, but it doesn't seem fair that I had to prepare for things and they didn't.
And you thought that Avery only won these awards based on her looks.
Based on her looks, what do you mean?
You stated that Avery only won the awards not based off of her talent, but based off of her looks.
Based off of how she could just pull something off and didn't have to prepare for it.
It is your statement here today that you did not say that Avery only won competitions based off of her looks.
No, I did say that in my affidavit.
Thank you. You weren't rivals, but you thought the team would be better off without Avery.
Yes.
And you weren't rivals, but you were excited to have a higher place on the team once you knew Avery would be gone.
Everyone would be excited to have a higher place on a team.
I would like now to direct your attention to your role in the police's investigation. You were asked to bring in your cell phone to the police.
I was.
As a result of some text messages that Avery sent you.
Yes.
However, when you went into the police, you left your phone at home.
I did.
Not allowing the police to fully examine these messages.
No.
Instead, you were asked to send in screenshots.
I was.
And conveniently, you no longer have the messages with the phone, or the phone with the messages on it.
I do not have the phone anymore, no.
And by only having to send in screenshots, it's possible that there was more to your conversation with Avery Becker than what has been shown.
That could 100% be possible, but I did send in screenshots of our messages.
You could have had prior conversations with Avery.
We were on the team together for 4 years. We have texted before.
But you never turned in your phone.
No.
And the police never saw the text messages on your phone.
They did not see it on my phone, but I was asked to turn in these screenshots.
All they ever saw were screenshots.
Yes.
Meaning that the court will never be able to see the messages off of your phone either.
Not now, no.
Or any other possible conversation between you and Miss Becker.
Not at this point, no.
Thank you, Your Honor. No further questioning.
Redirect.
Yes, Your Honor. Ms. Cifuentes, you left your phone at home because it was charging, right?
That is correct.
And you don't have the phone anymore because you
Objection, Your Honor, leading questions.
Sustained.
I'll rephrase.
Please rephrase.
Why do you not have your phone anymore, Ms. Cifuentes?
I had turned it in to the police.
Ms. Cifuentes, can you please re-answer that?
I don't have it anymore. It was charging. They just asked me to send in the screenshots. I see no reason to bring it to court.
And why do you not have the phone that had the messages on it anymore?
I got rid of it.
All right. Thank you. No further questions.
Any recross?
Recross. It is your statement in redirect that you did not bring in your phone that you did bring in your phone to the police station.
No, I did not. I was confused on her question. That's why she re-asked it.
But you did answer in court that you did bring your phone in to the police department.
As I have stated, I did not bring it in to my interview.
Thank you, Your Honor. No further questions.
Thank you. This witness is excused. Prosecution's next witness.
Prosecution calls Kyle Kuzak to the stand.
Thank you. Counsel, you may proceed.
Ms. Kuzak, please state your full name and spell your last for the record.
Kyle Kuzak, K-U-Z-A-K.
And why are you here today, Ms. Kuzak?
I'm here to testify on the behalf of the prosecution to the facts and evidence of the case.
All right. And Ms. Kuzak, what is your profession?
I am a Colorado Bureau of Investigation certified crime scene reconstructor and analysis.
And how long have you been a crime scene reconstructionist?
19 years now. In the past 3 years, I've been working for the Denver Police Department as a civilian.
All right, and let's talk further about your occupation. Will you please explain what a crime scene reconstructionist is?
I look at all the facts and evidence of the case and organize and memorialize it to put together a timeline of what happened the day of the crime, as well as possible suspects.
And what kinds of crime scenes have you worked with?
Well, I've been doing this for 19 years, so I've seen a lot. Home invasion, burglary, domestic abuse, fatal car accidents, homicides, really, you name it.
All right. And what professional principles guide your work?
2 key principles have always guided my work. It's memorializing all the evidence and the mindset that every case will go to trial.
All right. And what procedures do you follow when doing your work?
I follow the Tom Bibble and Ross Gardner 7-step methodology in memorializing and organizing evidence.
All right, Your Honor, at this time, prosecution would like to enter Kyle Kuzak as an expert in crime scene reconstruction and investigation.
Defense?
Your Honor, a brief voir dire.
You may.
Mrs. Kuzak, you don't list any former education, do you?
No, I was not asked to bring in a CR, but I've been doing this job for 19 years now.
And you don't list any training?
No, I wasn't asked to bring in a CR.
Your Honor, I have no objection to this witness being entered in as an expert witness in crime scene reconstruction. I just ask that she stays within the scope of her expertise.
Thank you, counsel. The witness is admitted as an expert in crime scene reconstruction.
All right, Ms. Kuzak, let's talk about how you approached this case. When did you first arrive at the crime scene?
I first arrived at the crime scene on March 6, 2020, after it had been processed by the crime lab.
And how did you first approach this case?
I approached it like any other case. I walked through the crime scene itself to look at the physical evidence on scene. I then received all of the crime scene photos and evidence from the police department and organized and memorialized it.
All right. And is there anything in the evidence that stood out to you?
I reviewed all of the evidence in depth, including some that have now been corrupted, I believe, but I really just organized it and put it together.
All right. And Ms. Kuzak, how many suspects did you investigate?
I investigated a total of 3 suspects. Our defendant here today, Avery Becker, and then Alex Cifuentes and Blair Rollins.
And was there any specific way that you organized this investigation?
Yes, I have a witness tracking sheet that has a key points of all the witness statements, as well as a timeline of the events that I believe occurred that day, as well as a evidence tracking sheet.
Your Honor, permission to screen share Exhibit 17.
You may.
Thank you, co-counsel. Without going into the contents, Ms. Kuzak, what is this?
This is my witness tracking sheet.
And is this a fair and accurate representation of what you used?
Yes.
Has it been altered in any way?
No.
All right. Ms. Kuzak, if you will, on the first row where you talk about Taylor Perkins, at the very bottom of the last column, suspect 3 is Blair Rollins, and they are unlocated. Will you please explain this decision?
Yeah, So I decided to, Blair Rollins was brought up to me later in the investigation after all the evidence was already pointing towards Avery Becker, the match of the height and build, as well as I believe that she was found in the area. However, the only concerning thing about Blair Rollins was that her height and build matched. And if that was the only thing, I found it useless to track her down, really.
Your Honor, permission to admit Exhibit 17 into evidence.
Defense?
No objections, Your Honor.
Exhibit 17 is admitted?
And permission to publish to the jury.
You may.
All right. Thank you, co-counsel. All right. And your witness tracking sheet, how did it help your investigation?
It helps me organize each witness, key points of their statements, how they know each other, and also point out suspects.
All right. Now, on to what you found in the ring videos. You viewed them, yes?
Yes, that's correct. I received them from the police department and reviewed them multiple times during my investigation.
And how did they help your investigation?
They helped me put together a rough timeline as well as identifying a suspect.
Your Honor, permission to screen share Exhibits 10 and 12?
You may.
Ms. Kuzak, without going into the contents, what are Exhibits 10 and 12?
They're the two of the ring videos, 10 being the intruder approaching Brackman's home and trying to get into it, and then the second being Exhibit 12 being Brackman's back door and the perpetrator going in.
All right. And is this a fair and accurate representation of what you received and viewed?
Yes.
Have they been altered in any way?
No.
All right. Your Honor, at this time, prosecution would like to admit Exhibits 10 and 12 into evidence.
Defense?
No objection, Your Honor.
Exhibits 10 and 12 are admitted.
And permission to publish to the jury.
You may.
Co-counsel, will you please play Exhibit 10? Thank you. And now Exhibit 12. Thank you, co-counsel. You may stop screen sharing. So, Ms. Kuzak, what stood out to you about the person in these videos?
The biggest thing that stood out to me was the match of height and build to Avery Becker, our defendant here today. And then the second being that the perpetrator was wearing a mask, a Halloween looking one, as well as gloves, which hindered getting physical evidence on scene, such as fingerprints, but as expected with the gloves on.
And how did this information impact your investigation?
Well, the height and build is what pointed me towards Avery Becker.
All right. And on to your final conclusion. In your expert opinion, what happened first on the day of March 6, 2020?
First, the perpetrator approached the door of Brackman's home and attempted to open it, then finding it was locked. This is when Brackman was alerted via his phone on the Ring app of the intruder's presence, and so he went to grab a defensive weapon, being a knife, in the kitchen. This is when the perpetrator was making their way around the house, and once the perpetrator got to the back door and entered the house, they were met with Brackman with a knife.
And what happened after the intruder entered the home?
I believe that a struggle ensued over the knife.
What led you to believe a struggle occurred?
Well, there were scuff marks on the ground right inside the back door of Brackman's home, as well as a broken plate near his table. So I believe that the scuff marks was from pushing or shoving, and then the broken plate is when they bumped into the table.
Your Honor, permission to screen share exhibits 9 and 18.
You may.
All right. All right, Ms. Kuzak, without going into the contents, exhibit 18, what is this?
This is right inside of Brackman's back door where I found the scuff marks.
And exhibit 9?
This is in Brackman's home where the plate was shattered on the ground.
Is this a fair and accurate representation of what you viewed?
Yes.
And have these photos been altered in any way?
No.
Your Honor, at this time, prosecution would like to admit exhibits 9 and 18 into evidence.
Defense?
No objection at this time, Your Honor.
Exhibits 9 and 18 are admitted.
And permission to publish to the jury.
You may.
And Ms. Kuzak, why did this specifically indicate a struggle?
Well, scuff marks are formed from blunt force of a shoe on the floor from pushing or shoving, and then the broken plate occurred when they bumped into the table, I believe.
Thank you, co-counsel. And what occurred during their struggle, Ms. Kuzak?
Well, they fought over the knife trying to gain possession, and so they went from the back door where the scuff marks were created into the dining area, bumping into the table, causing the plate to fall and break. Then once the perpetrator gained the knife, they ended up in like a bear-like hug.
And how did this encounter end?
It ended, unfortunately, during this bear-like hug, the perpetrator reached over and stabbed Brackman in the shoulder blade area. This is when the perpetrator fled the scene, and then Brackman followed in suit, taking the knife out midway down the hallway, which quickly led to his death.
And with all of this evidence, in your expert opinion, who killed Mackenzie Brackman?
In my expert opinion, Avery Becker killed Mackenzie Brackman.
Thank you, Your Honor. No further questions.
Cross-examination?
Yes, Your Honor. Mrs. Kuzak, is there any way to put a date on when those scuff marks occurred that you witnessed at the crime scene?
No, there isn't, but I used other evidence on the crime scene, such as the broken plate, to infer and really make an educated guess as to those scuff marks being from the day of the murder.
And Mrs. Kuzak, you made a witness tracking spreadsheet, as you said, on direct examination, correct?
That is correct.
Your Honor, can I show the witness what has been entered into evidence as Exhibit 17?
Yes, you may.
The letter S on this witness tracking spreadsheet means suspect, correct?
That is correct.
And you list 3 suspects?
Yes, the first being the defendant here today, Avery Becker, the second, Alex Cifuentes, and the third being Blair Rollins.
And this was after a thorough investigation?
Yes.
And you are very thorough in your work itself?
Oh, yes, of course.
And Mrs. Alex Cifuentes' name is spelt incorrectly on this form. You spelt it Alice Cifuentes?
Yes, it just looks to be a typo.
Moving to the crime scene, you went there after a team, correct?
Yes, I went there after the scene was processed, as I do in every case.
And nobody found any DNA evidence there,
That is correct.
meaning you don't have any DNA of a suspect.
No, but that was a given with the perpetrator wearing gloves.
And the intruder was wearing a mask.
That is correct.
And this means you can't tell who the intruder is?
No, not from facial recognition. However, in my investigation, I used the height and build of the perpetrator in the ring videos to identify suspects.
And so you don't have a face for the intruder?
That is correct. They were wearing a mask.
Finally, Mrs. Cusack, you don't have any evidence at all to put my client at the crime scene.
That is incorrect. I have the height and build of the perpetrator matching the height and build of your client, Avery Becker.
So that is, you're stating no, there is no evidence?
I'm saying there is evidence. The height and build of Avery Becker is that of the perpetrator, and that is evidence.
No further questions at this time, Your Honor.
Redirect.
Yes, Your Honor. Ms. Cusack, what other evidence led you to believe that it was Avery Becker?
I have been told or informed that Avery Becker was also found in the area at the time of the murder.
All right, thank you. No further questions.
Any recross?
No, Your Honor.
Thank you. This witness is excused. Prosecution's third witness.
Your Honor, prosecution calls Detective Jordan Markowitz to the stand.
Thank you. May proceed.
Please state your name and spell the last for the record.
Jordan Markowitz, Markowitz.
Why are you here, Mr. Markowitz?
I am a homicide detective with the Denver Police Department, and I'm here as a witness in the murder of Mackenzie Brackman.
Let's talk about your career. How long have you worked with the Denver Police Department?
I've been with the Denver Police Department for about 13 years, and then I've been a homicide detective for the past 7.
And what fields do you specialize in?
I specialize in cell phone data and then also forensic data recovery, so cell phone technology as well. And then also I mentioned I am a homicide detective.
Do you have any specialized training?
I had to take a 3-day training course to be certified in what I am, and then also had to pass the certification test.
What did you learn during this training?
Well, I learned how to use systems like the Cellubrite system, and then also how to access and acquire and interpret cell phone data, and then also cell tower data.
And what is your experience using this training?
Well, I've accessed at least 100 cell phones to access their data, and then within at least 50 cases, I've used cell tower data.
Your Honor, at this time, prosecution would like to enter Detective Jordan Markowitz as an expert in homicide investigation, cell phone technology, and forensic data recovery.
Defense?
A brief one here, if I may, Your Honor.
You may.
Detective Markowitz, you say you've completed a cell phone technology and forensic data recovery course. Is that correct?
Yes.
And this course is only 3 days long. Is that correct?
It was a very long 3 days.
But 3 days is relatively short to your 13 years of experience.
Yes.
And in those 3 days, you learn everything there is to know about cell phone technology. Is that correct?
Yeah, about it.
Yet all of that data can be retained in only 3 days?
Yes.
Your Honor, at this time, I have no objections to this witness being entered in as an expert, as long as they stay within their confines.
Thank you. The detective is admitted as an expert in homicide investigation, cell phone technology, forensic data recovery. May continue, counsel.
Thank you, Your Honor. Moving on to the day of the crime, what happened on March 6th, 2020?
Well, on March 6, 2020, we received a a notice from a near motorist, and he mentioned that there was a person passed out in front of their house. So paramedics were first to arrive, but then the officers were called onto the scene.
And what did you see whenever you arrived on scene?
Well, when I arrived on scene, I first noticed the victim, Mackenzie Brackman, laid down in a pool of their own blood with a knife very close to their body.
What did you notice about the crime scene?
Sorry, can you say again?
What did you notice about the crime scene?
Oh, well, when I walked onto the crime scene, I also noticed that there was a Ring doorbell on the north side of the house, right next to the door, the front doorway. And then later on within my investigation, I did notice that there was another Ring doorbell on the south side.
And how did you use these Ring doorbells in your investigation?
Well, I was able to access the data from the Ring doorbells within the day of the murder, and we were able to access videos of the suspect trying to get into the house through the front door and later entering it through the south side.
Is there anything to know about this person?
The person has the same build as Avery Becker, same height and build.
And let's talk about your knowledge of cell phones. What do you know about them?
Well, cell phones can communicate over large areas, and a single cell phone tower can communicate within a radius of 162 miles. But in more rural areas, more urban areas, they're more packed and tightly busy. So those can only cover about 7 miles. So the cell phone is able to connect to multiple towers, this meaning the cell phone is designed to select the tower with the better connection connecting to the network.
And how did you use to locate the defendant?
Well, at the time of Mackenzie Brackman's death, the cell phone of Avery Becker's pinged the nearest tower nearest Brackman's home. This put them in the area of the crime at the time as well.
And what conclusion were you led to by this?
I was led to believe that Avery Becker was in the vicinity of Mr. Brackman's home when he was murdered.
You interrogated Alex Cifuentes. Can you please identify her today?
Oh, she has curly light brown hair and glasses on.
When you spoke to her, what did you find concerning?
Well, within our interaction, she did mention something about text messages between Avery Becker and herself.
Please describe these text messages.
Well, within these text messages, Avery Becker is telling Alex Cifuentes about how she got kicked off of the mock trial team, asking for Alex's help. Alex does decline to help, and then also Avery Becker later on mentions that she is going to break into Mackenzie Brackman's home and trash it.
Prosecution response to the hearsay objection.
Your Honor, this is not hearsay because these text messages have been entered into evidence and they say those specific things that Miss Markowitz has responded to.
Your Honor, if I may.
Any other argument? You may.
Judge, if we're also talking about this, that these have already been entered into evidence, I'd also like to add the objection to cumulative. Since the jury already has these text messages in front of them, we don't need Detective Markowitz reading off these text messages, as it is only going to waste the court's time.
Any other response?
No, Your Honor.
Objection is overruled.
With all things considered, what is your final conclusion of this case?
In my expert opinion, I am to believe that Avery Becker herself was in the vicinity of Mr. Brackman's home and intended to break into the home.
The issue.
I'm sorry, was there an objection or something in there?
Yes, Your Honor, on the grounds of ultimate issue.
Oh, I'm sorry. Counsel, you may respond.
Your Honor, I don't see how this is an ultimate issue because we are talking about evidence that has been entered and she is simply stating her overall thoughts of the case and what her final conclusion is.
Your Honor, if I may have a moment.
You may.
Rule 704B, the Jordan Markowitz is testifying to intent, that my client intentfully did something, and for intent is motive and state of mind, and that is exclusively for the trier of the fact, the jury alone, and therefore it is ultimate issue.
Your Honor, may I respond?
You may.
However, Your Honor, my witness is not making any accusations off of the grounds of what you've said. My witness is simply stating her expert opinion and what she believes happened with this case.
Good argument from both counsel. The objection's overruled. May continue.
I'll re-ask the question, Ms. Markowitz. With all things considered, what is your final conclusion of this case?
I am to believe that Avery Becker attempted to break into the home and trash the home of Mackenzie Brackman, and in process of doing this, did face Mackenzie Brackman herself, and instead had to have an altercation with Mackenzie Brackman, in the end stabbing Mackenzie Brackman and leaving the vicinity.
Thank you, Your Honor. No further questions.
Cross-examination.
Yes, Your Honor. Detective, you arrived at Mackenzie Brockman's residence at approximately 2:20 p.m., is that correct?
Yes.
And upon entering the residence, you noted Mackenzie Brockman's body near the front door.
Yes, I did.
And you knew Mackenzie Brockman before this incident, is that correct?
Yes, I've had, he has crossed me multiple times within cases.
And next to his body, you found a knife, is that correct?
Yes, it was very close to the body.
Moving on, you say you took photos of the crime scene, is that correct?
Yes, I did.
And some of these photos were conveniently corrupted, is that correct?
Unfortunately, yes.
These photos were lost.
Unfortunately, yes.
They are not able to be presented to the jury today.
Because they are lost, yes.
I'd like to draw your attention to Exhibit 14. You received screenshots of a conversation between my client and Alex Cifuentes, is that correct?
Yes, I did.
Objection, Your Honor. Exhibit 14 has not been entered into evidence.
Counsel, it has.
My bad, then.
And Detective,
May continue.
Detective, at the time, Ms. Cifuentes did not have her phone with her, is that correct?
She claimed that she left it at home because it was dead.
And you accepted these screenshots without question, is that correct?
Yes, I did.
You never followed up on examining Ms. Cifuentes' phone?
No, I did not. I just asked her to send the screenshots.
You never verified that these screenshots were accurate?
No, I did not.
And you never saw the physical text messages on Ms. Cifuentes' phone?
No, because like I said, I did only ask for the screenshots because she did not have her phone on her at the time.
And Detective, you mentioned about cell detail records.
Sorry, can you ask again?
You mentioned something about cell detail records, is that correct?
Yes, I did.
And you were able to get a warrant for my client's cell phone cell detail records, is that correct?
Yes, I was.
And Detective, cell phone detail records are not always accurate.
Not all the time, no.
They can connect to a different tower if the current tower is busy.
Yes.
And Detective, they also don't guarantee that someone was with their phone at the time, is that correct?
Yes.
Just because someone's cell phone is somewhere does not mean that they are with that cell phone?
I guess, but I don't understand people who would just leave their cell phone, especially the teenagers.
Is that a yes or a no?
Yes.
Thank you. No further questions at this time, Your Honor.
Redirect.
Yes, Your Honor. Ms. Markowitz, why did you want to see only the screenshots of the text messages?
Because I only asked her to send the screenshots of the message. I didn't need to see her physical phone. I only needed the screenshots.
And again, I'll ask you, Ms. Markowitz, do you believe that Avery Becker was in the vicinity of her location?
Yes, with all evidence proven from the cell tower records, Miss Becker's phone connected to the cell tower closest to Mr. Brackman's house.
Thank you, Your Honor. No further questions.
Any recross?
Briefly, Your Honor. Detective, you stated that you were able to find my client's cell phone records, is that correct?
Yes.
That would imply the location of my client's phone.
Yes.
Not my client.
Yes.
Thank you. No further questions.
Thank you. This witness is excused. Everyone still doing okay to continue on? Defense may call your first witness.
Your Honor, defense calls, Blake Van Owen to the stand.
Thank you. You may proceed.
Please state your name and spell it for the record.
My name is Blake Van Owen, Van, V-A-N, Owen, O-W-E-N.
And Ms. Van Owen, what is your occupation?
I'm a private investigator and also a professor.
Do you have any other job experiences?
Yes, I first started working at the Aurora Police Department as a law enforcement officer. Then I transitioned to an SRO, or a school resource officer. Then I worked as a private security guard, then transitioned to private investigating.
What training have you completed in your field?
So I first received my bachelor's degree in 2005 from University of Colorado, Boulder. Then I began working at the Aurora Police Department as a law enforcement officer. I then transitioned to, like I said, an SRO. I began after leaving, I'm so sorry. I worked at the Aurora Police Department. After leaving the police department, I began teaching police procedures at Community College of the Rockies. I then I went to get my master's degree from Ashford University's online program, which was in criminal justice. And then I began working as a professor at CU Denver, teaching social justice and police practices.
Have you ever previously testified in court?
I have. I'm actually been accepted in the U.S. state courts for Colorado, Kansas, and Arizona, and then for the state courts for Colorado, Wyoming, Nebraska, and New Mexico. And I've been an expert in I've been an expert in 25 cases and consulted in over 100.
In what fields have you testified as an expert witness?
I've testified in crime scene reconstruction 8 times, cell tower data analysis 5 times, and then overall police practices 12 times.
Your Honor, at this time, we move to enter Blake Van Owen as an expert witness under Rule 702 as they reach the criteria of knowledge, skill, expertise, training, and education.
Prosecution.
No objections, Your Honor.
The witness is so qualified as an expert in those areas.
Why are you here in court today, Professor Van Owen?
So I'm here to testify on behalf of the defense as someone who has knowledge of police practices and my time as a private investigator who has consulted on this particular case.
And how did you get involved with this case?
Well, I was asked by the defense to give my expert opinion regarding the case.
What fields were you asked to testify to?
I was asked to give the opinions that Mr. Brackman was not guaranteed to have been stabbed during a struggle, to establish the fact that Becker's phone was not at the crime scene and neither was Becker, and finally to establish that the prosecution's case just wasn't methodologically sound.
And what materials did you review in order to create your conclusion on the case?
I reviewed the crime scene investigation, the cell tower data, and the cell tower data overall, and the police reports. The police report, cell tower data, and the crime scene investigation.
What were your opinions regarding the reports given by Detective Markowitz and Kyle Kuzak?
After reviewing the materials by Detective Markowitz and Kyle Kuzak, such as the ones mentioned prior, I noticed that it was a partial investigation that was done. Oh, sorry.
No, finish your answer, please.
So I felt that I needed to do a little partial investigation of my own.
And why did you believe that you needed to do your own partial investigation?
Well, I only did the extra research in the areas that I believe that the prosecution had neglected. It was unfortunate that the material given to me was only a reflection of what was convenient to them at the time. And as a result, there was quite a bit of information that was missed. You cannot call it evidence if it's solely based off of assumptions.
And in your investigation, what was this material that you reviewed?
I reviewed the murder weapon, the method of killing, the cell tower data, and the prosecution's overall case.
And with this material you reviewed, you wrote a report for the court today.
Yes, I did.
According to your opinion, how was Mr. Brackman most likely killed?
Well, rather than any kind of struggle, it was most likely that Brackman was killed while sitting down.
And why do you believe this to be true?
Well, according to my findings, from the position of the knife, it would have to have been very specific to have killed Brackman, and by piercing the scapula and nicking the aorta, which was the cause of death noted. Also, the person would have had to stab Brackman from behind and would have had to been of a much larger build. And for both of these to have been true, it would provide evidence to explain how Brackman would have died, and as well as what to look for in a murder suspect.
Would it be at all possible for someone of a similar build to have overtaken Brackman?
No, the assailant would have had to have been of a much larger stature, as I previously stated, to have been able to stab from the demonstrated angle within my report. This all made the possibility of the struggle very unlikely and not certain to be the scenario.
And how would the victim have prior notice to being attacked?
Well, in reality, Brackman wouldn't have known. The Ring doorbell notifications previously stated by the prosecution supposedly would have given a warning to Brackman, but since there were no records proving that this happened, no one knows this for a fact.
I would now like to discuss the information about the cell phone towers. What is the coverage of an average urban cell phone tower?
So an urban cell tower covers about a 6 to 7 mile radius.
And how can you identify where a phone is within the sector?
Well, on these cell towers, there are antennas, and each antenna represents their own sector. And based off of these sectors, you can somewhat pinpoint an area within the sector that the phone could have been.
And is this method of location always reliable?
No, it's not at all, because there, like previously said in the prosecution, the cell tower gives you an approximate area, but cell towers can get busy. So if the nearest cell tower is busy, your phone won't necessarily connect to that one. It will connect to one that's either further away or less busy.
And in your opinion, what is the possibility of Avery Becker being within the radius of Mr. Brackman's home, according to the range of the cell tower?
So if Avery Becker's phone had pinged off of the cell tower near the victim's house, there's no definite evidence showing that the phone or Avery was in that area. Like I said, the phone could have connected to one that was just less busy.
I want to go back to reference the specifics of why you decided to conduct your own investigation. What specifically motivated you to conduct your own research?
Well, there were many aspects of the prosecution's case that had been rushed and they had failed to be attentive to. Instead, they came up with a theory based off of incomplete evidence.
You mentioned incomplete evidence. What are you referring to?
The pictures of the blood drops and the cast off near the front door were actually lost by the prosecution. Apparently, the image files were corrupted. How convenient. And not only that, the investigation from the prosecution's witness, Detective Markowitz, on the cell tower data got only a limited window instead of getting the records for the full day, just only the time frame of the murder.
And what happened with the screenshots provided by Alex Cifuentes?
Honestly, I was surprised that the prosecution and the police actually used them to build their case instead of obtaining the phone, downloading the text messages off of it, or looking at the text messages. Obviously, this was a matter of what was convenient to them at the time and with no interest in providing any actual evidence in their investigation.
Is this a normal procedure used in police practices?
It's not a normal procedure at all. The police actually have special hardware for the specific purpose. Detective Markowitz mentioned earlier that they have training in Celebrite. Celebrite is actually a software used to download contents off of phones. If the prosecution really wanted to find the murderer, they would have taken the phone, used this software, and downloaded the messages off of it.
In your expert opinion, Professor Van Owen, did Avery Becker kill Mr. Brackman?
Well, there's no evidence that lines up with Avery to have been the one to kill Brackman. Honestly, there is more evidence leaning towards Blair Rawlins to have committed the murder.
Who is Blair Rawlins?
Blair Rawlins is the child of Jonathan Rawlins, who was actually a former client of Mr. Brackman.
And why do you believe it to be Blair Rawlins that killed Mackenzie Brackman?
Blair has a stronger motive to kill Brackman than Avery would, since Brackman was the reason that Jonathan, Blair's father, was put into prison. So it would seem more likely than not.
Thank you, Your Honor. No further questions at this time.
Cross-examination?
Excuse me, Your Honor. So sorry to interrupt, but
yes.
have been disabled, therefore timekeepers cannot put the time remaining in the chat.
Is our Zoom coordinator present to reenact or reactivate the chat feature? Let me see if I can. No, I can't. Do we have our, I'll notify Mr. Downey. What can you, can the timekeepers tell us at the conclusion of each section where time is?
Yes, Your Honor.
Thank you.
The event has 13 minutes and 17 seconds left for direct.
All right. Thank you, Cross.
I'm sorry,
Professor Van Owen, good afternoon.
Hi.
You were hired by the defendant's family, correct?
Correct.
All right. And your crime scene reconstruction, you review the work of crime scene reconstructionists, correct?
Correct.
And you've only testified as an expert in crime scene reconstruction in 8 cases?
That is correct. But I've also consulted on many other cases.
So that is a yes, you have only testified in crime scene reconstruction for 8 cases.
Correct.
Are you yourself certified by the Colorado Bureau of Investigation in crime scene reconstruction?
No, but I've been accepted in multiple courts in different states and different districts.
I am only asking if you are certified, yes or no?
No.
All right. So let's talk about your investigation. You believe that the prosecution rushed some areas of this case, correct?
Correct.
And you believe one of these areas is the cell tower data that was obtained?
Correct.
Did you yourself follow up on that and get the cell tower data for the entire day?
No, I did not.
And you've also said that the police department could have downloaded the contents of Ms. Cifuentes' phone.
They could have.
Did you yourself download the contents of Ms. Cifuentes' phone in your investigation?
No, I did not. Because I had nothing to do with that area. If they were the ones specifically looking for the phone, if they wanted to see the text messages, if that was really what they wanted, they would have done that.
So no, you did not download the contents.
No, I did not.
And the text messages, you believe those are false?
I did not say that. I said that there's a possibility that they could have been corrupted.
But did you do the work to confirm whether or not they were corrupted?
No, I did not.
And finally, Blair Rollins, you believe that they were not investigated thoroughly enough?
Well,
Yes?
could you please re-ask your question?
Yes. Blair Rollins, you do not believe that they were investigated thoroughly enough, correct?
I never said that. I mean, I feel like there could have been more investigation on all aspects for Blair.
All right, but did you yourself find Blair Rollins?
No, I did not.
All right, thank you, Your Honor. No further questions.
Redirect.
Yes, briefly, Your Honor. Was it your responsibility to obtain these cell phone records?
No, it was not.
What conclusion were you able to come to based off of the evidence that that you were provided with from the prosecution's case to build your own?
Like I said prior, the case overall was not methodologically sound. There were a lot of aspects that were missing.
Thank you, Your Honor. No further questions.
Anything else from the prosecution?
No, Your Honor.
No. All right, thank you. This witness is excused. Defense witness number 2.
At this time, Your Honor, the defense would like to call Taylor Perkins to the stand.
Thank you. Do we have Ms. Perkins up? There we go. All right.
Please state your name and spell the last, Mr. Perkins.
Taylor Perkins, Perkins.
And why are you here today, Mr. Perkins?
I'm here today to testify for my friend Avery Becker, who's being accused of crimes she did not commit. There's no way that she could have committed murder.
And who was Mackenzie Brackman to you?
Brackman was our mock trial coach. He never made the best decisions for the team and always gave Avery a hard time, even kicked her off the team. I mean, I'm still sad that he's gone and I miss him.
And why did Avery get kicked off the team?
Avery had received some awards during regionals, and Brackman said that she didn't deserve them. And on Avery's way out, she marked Worst Attorney Award on the hood of Brackman's Porsche. She didn't realize until later that it was permanent marker.
And how did she act after that night?
She seemed very upset. She tried to apologize to Brackman on multiple occasions, and she acted like she felt really sorry for the way she acted that night. Unfortunately, she never got the chance to apologize.
Moving to the night before the murder, where were you?
Avery and I were at my house. We were playing video games on our phones, and then we went to the Fry Shack and the mall. The Fry Shacks were all the mock trial students like to go.
And who was at the Fry Shack?
Our mock trial team was there, as well as that brown noser, Alex Cifuentes.
And who is Alex Cifuentes?
Alex is a student on the mock trial team. She seemed jealous of Avery's skill set, and they never really got along.
And what happened at the Fry Shack?
Alex must have made Avery very upset, and Avery stormed off to the bathroom. She left her phone on the table. Avery never forgets her phone. It's like a third kidney to her. When she came back, we left.
And who was at the table when you guys left?
Alex Fuentes was. Pretty convenient, if you ask me.
Moving to the tragic day of March 6th, 2020, what happened that morning?
Avery came by and picked me up to go to school, and later, when we were on our way, we realized her phone was missing.
And what did you guys do after you realized Avery's phone was missing?
We searched anywhere where her phone could have possibly been. We went to the Fry Shack, we went to the mall, any other store that we could have been to.
And did you guys ever find Avery's phone?
No, we didn't. It's still missing to this day.
And when was the last place you remember seeing Avery's phone?
I remember seeing it on the table at the Fry Shack near Alex Cifuentes.
And how long were you with Avery Becker on the day of March 6th, 2020?
It was most of the day. It was when school would have started to when school would have ended and when mock trial practice would have started.
And finally, Mr. Perkins, do you have any closing words you would like to say?
Well, I'm still in shock about Coach Brackman's death, and I really don't think that Avery could have committed these murders, let alone burglary or murder.
No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Mr. Perkins, you and Avery Becker are best friends, correct?
That is correct.
Did you observe any conflict between the defendant and Mackenzie Brackman?
Yes, Brackman always gave Avery a hard time.
And you were not at the practice when the defendant wrote Worst Attorney Award on Brackman's car?
No, I was not, but Avery told me about it.
So you only know about it from what Avery told you?
That is correct.
Objection, Your Honor. Relevance.
Counsel?
I'm just going to show that the witness was not at the practice during the prank on Mr. Brackman.
Your Honor, if I may, I don't see how a prank has anything to do with a murder trial.
The objection's overruled. You may continue, counsel.
Thank you, Your Honor. And you claim you were with the defendant the day that Mackenzie Brackman died?
That is correct.
Was anyone else with you on March 6th, 2020?
It was just me and Avery.
So no one else can say that you were with the defendant?
That is correct.
Thank you, Your Honor. No further questions.
Redirect.
No, Your Honor.
All right. Thank you, Mr. Perkins. You're excused. Defense third witness.
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
Thank you. You may proceed.
Please state and spell your last name for the record.
Avery Becker, Becker.
And where did you go to high school?
Last year, I attended Colorado High School as a senior. I was also part of the CHS mock trial team.
Let me take you back to the events on March 6th of 2020. Where were you on that day?
On March 6th, I was with my best friend Taylor all day. We were searching for my missing phone that I had lost the day before.
Where did you last see your cell phone?
The last time I remember seeing my phone was at the Fry Shack on March 5th. Taylor and I were playing video games on our phone.
Who all was at the Fry Shack?
The mock trial team was there, as well as particularly Alex was also there at the time.
And who is Alex?
Alex is a fellow teammate of mine on the mock trial team, but we've never really gotten along.
How would you describe your relationship with Alex Cifuentes?
Well, like I said, we didn't get along, and Alex was always jealous of me because I was the best attorney.
Objection, Your Honor, hearsay. The witness cannot testify to how Alex Cifuentes feels.
Counsel?
Your Honor, I don't think this is a hearsay objection. I think if what counselor is going to, it's speculation. But since they've been on a team, as Alex Fuentes has testified in court today, since freshman year, I think she would have the rationally based perception, as stated in Rule 701, to understand how she would feel.
Any other response from the prosecution?
Your Honor, this witness is still testifying to how Alex Cifuentes feels and Alex Cifuentes' quote jealousy, which she cannot testify to because she cannot make that speculation or anything like that.
Thank you, counsel. The objection's overruled. You may continue.
Ms. Becker, did you listen to Ms. Cifuentes' testimony today?
Yes, I was present for that.
Could you reference Exhibit 14 for me on the stand, please?
Yes.
Can you describe what this is?
I'm not really sure. I've never seen this before, and I didn't send these text messages.
And Ms. Becker, did you send these text messages?
No, I mean, it conveniently says that I went to Coach Brackman's house, but I don't even know where he lives. So no, I never sent these text messages.
Let's move on to your relationship with your coach, Mackenzie Brockman. How would you describe your relationship with him?
Coach Brackman and we've never really been on the best terms. He always critiqued my work ethic.
And what happened because of his complaints?
Well, he even demoted me to B team because of it, despite me being the best attorney on the team.
What happened after you were demoted?
Well, afterwards, Taylor felt bad and had this idea to quit mock trial because he believed A team couldn't win without me. And then afterwards, Coach Brackman put me back on the team.
Were there any major conflicts with Mackenzie Brockman afterwards?
Yes, after all regionals competition, Coach Brackman started critiquing my work again. And although we just won regionals because of me, he started going at it.
And what happened afterwards?
I got angry at the time and grabbed a marker and went out to his portion and wrote Worst Attorney Award on it. But it was one of my dumbest decisions in my life.
What were your feelings afterwards?
After I calmed down, and I truly regretted that. And if I wanted to go apologize to Coach Brackman.
After you wrote on his car, what did you do?
So the very next day, I went to Coach Brackman's office to try and apologize to him in person, but he didn't want to see me. I even offered to work the whole summer to pay off for the damages I did to his car, but I will never get the chance to apologize to him in person and never will now.
Ms. Becker, did you kill Mackenzie Brockman?
No, like I said, I don't even know where Coach Brockman lived. The only thing I ever did was scribble on his car, but I would never do anything to hurt my coach.
Is there anything else you'd like to say to the court today?
Yes, all I have to say is I am truly sorry for what I did to Coach Brackman's call and wish that I could get the chance to apologize to him, but I will never. However, I am still innocent and would never do anything to hurt my coach.
Thank you. No further questions at this time, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Mrs. Becker. You sent threatening messages to Alexa Fuentes, correct?
Objection, argumentative.
Counsel?
Your Honor, I'm just simply asking if she sent text messages to Alexa Fuentes.
Objections overruled. Witness may answer.
So, as I said, you sent threatening messages to Alexa Fuentes, correct?
No, I never sent those messages.
You believe that Alexa Fuentes stole your phone, correct?
Yes, as Alex was at the fight at the time.
You never saw them take your phone, though, correct?
No, I did not.
So you assumed Alexa Fuentes took your phone?
Yes.
You never reported your phone as missing?
No, but Taylor and we went around to the mall and Fire Shack to look for my phone on March 6th.
So that's a no. You never reported your phone as missing?
No.
Moving on, there was conflict with you and Mr. Brackman, correct?
Yes, we've never really been on the best terms.
And he demoted you to mock trial B team, correct?
Yes, he did.
You were hurt by this?
Yes, I was.
So you decided to vandalize his car after being placed on mock trial B team?
I didn't. I vandalized his car after our regionals competition, not when he demoted me to B team.
Your Honor, one of our teammates is having technical difficulties. Will Damon, the the directing attorney for Mrs. Becker. So we ask that we stop trial while he is getting right back on.
Thank you, counsel. Time, please, so we can get counsel's computer corrected.
Your Honor, as of now, Will is in the waiting room, and I don't know if you have the ability to let him in, but if you do.
I don't. Is our Zoom facilitator able to do that? I'll send a text to the leaders. She's still in the waiting room. I've sent a text. I thought we had a Zoom courtroom facilitator. I don't have host capabilities.
Yes, he still is in the waiting room, Your Honor.
Okay. Stand by. I can't even mute myself to try and call. Mr. Warner, I'm stuck because of my
I'm on the phone with Mr.
phone line.
Your Honor.
Okay, looks like,
Apologies.
there we go. So both the prosecution and defense stopped their timers while we were running into the technical difficulties, correct?
Yes.
Okay, thank you. We'll resume.
Alrighty.
Your
I'll.
Your
Oh,
Honor, if I may ask the opposing counsel to restate his question.
Yeah, that's.
Thank you. If you'd repeat your last question.
Yes. You were demoted to mock trial B team, correct?
Yes, I was.
And you were hurt by being demoted to mock trial B team, correct?
Yes, I was, considering I was one of the best attorneys on the team.
So then you continued to go and vandalize his car, correct?
Yes, after the regionals competition, not after my demotion.
You still vandalized his car though, correct?
I did regretfully, and if I could, I really did want to apologize to Coach Brackman about that.
You then later on said that you would get back at him if it was the last thing you did, correct?
Yes, I said that in an angry state, but once I calmed down, I didn't.
And you blamed the deceased, Mr. Brackman, for ruining your mock trial career, correct?
Yes, I did when I was angry at the time.
So you still blamed the deceased for ruining
Objection
your
asked
mock
and
trial
answered.
career.
Response from the prosecution?
I'm simply asking for a yes or no question from this witness. She did not provide that with the last answer.
Any other argument?
Your Honor, I believe my witness started off her response with yes and answering a yes to his question, but she's allowed to elaborate a little bit on the question. However, she gave a verbal yes to begin her question, and that question is just asking the same question which has already been asked.
Objections overruled.
I'll re-ask the question. So that's a yes.
Yes.
You then claimed that you ditched school the day of the crime, correct?
Yes, I went with my best friend Taylor to go find my missing phone.
And like you said, Taylor Perkins was with you, correct?
Yes, I did say that.
So your best friend is the only person who knew your location during the murder?
Yes.
No further questions, Your Honor.
Redirect.
Briefly, Your Honor. Miss Becker, how did you feel afterwards when you vandalized Mackenzie Brockman's Porsche?
I regret that decision that I made out of anger state, but once I calmed down, I truly felt sorry for my action, but I would never do anything else to hurt Coach Brackman.
Do you feel remorseful?
Yes, I truly do.
And to reiterate for the jury, where were you on March 6th?
On March 6th, I was with my best friend Taylor, and we went to the mall in Fleishak to search for my missing phone.
Thank you. No further questions, Your Honor.
Any recross?
No, Your Honor.
Thank you. Thank you. The witness is excused. We'll proceed to closing statements. Because the prosecution has the burden of proof, they'll proceed first. And when they finish their close, if we could make sure that our timers have posted if they've reserved any time for rebuttal argument. So counsel, you may proceed when ready. I appreciate you might need a moment to get yourself situated.
Good evening, Your Honor, ladies and gentlemen of the jury and opposing counsel. Today, we, the prosecution, have brought forward a case of revenge and teenage hubris. Avery Becker used their own best friend as an alibi to the crime that they committed. Avery Becker, in a fit of rage after receiving criticism from a school club, vandalized Mackenzie Brackman's car. Today, the prosecution had the burden of proof to prove beyond a reasonable doubt that Avery Becker murdered Mackenzie Brackman and burglarized his home. The defendant would have entered Mackenzie Brackman's home without his knowledge and murdered Mackenzie Brackman within this burglary to make it a first-degree murder. Today, we brought forward 3 witnesses. First, you heard from Alex Cifuentes, a close friend of Avery Becker, who had the courage to come forward with concerning text messages that led to the conclusion of this case. Then you heard from Kyle Kuzak, who spoke about the facts of this case. Ms. Kuzak was led by the evidence to believe that Avery Becker was the only reasonable suspect for the murder of Mackenzie Brackman. And then you heard from Detective Jordan Markowitz. Detective Markowitz used new technology and located Avery Becker. They were able to use the evidence at hand to pinpoint Avery Becker as the only reasonable suspect. The defense also brought forward 3 witnesses. They brought forward first Professor Blake Van Owen, a jack of all trades, master of none. Professor Van Owen claims that the prosecution had a rushed case, that it was incomplete, yet they did none of the work to confirm whether or not they were right. They claimed that was the prosecution's responsibility. Yet they also say that they conducted a partial investigation on what was necessary. None of the areas that they pointed out were neglected. Then you heard from Taylor Perkins, Avery Becker's best friend, the only person who can testify to the whereabouts of Avery Becker on March 6, 2020, who was supposedly with them all day. Then you heard from Avery Becker herself. Avery Becker, who told you the story that she wants you to believe. But actions speak louder than words. Avery Becker vandalized Mackenzie Brackman's car after receiving criticism. I don't think you have to imagine very much what would happen after being removed from the mock trial team. Today, we ask that you do what is right. Today, we ask that you find Avery Becker guilty and rule in favor of the prosecution. Thank you.
2:12 remaining for rebuttal. Defense may proceed to your closing statement.
Yes, Your Honor. Ladies and gentlemen of the jury, Your Honor, opposing counsel, what is right is often forgotten by what is convenient. Today, you have seen that the prosecution has brought to you a rushed and convenient investigation, taking what is easy and what is convenient rather than what is right or true. Today, the prosecution has brought to you 3 witnesses today. First, starting with Avery's supposed friend, Alex Cifuentes, who testified on the stand today that everyone is a rival. They were not friends. In fact, they sent the supposed screenshots from Exhibit 14. She never brought that into the police, never bringing in her phone, nor did she bring in any physical evidence of these screenshots. You as the jury are not able to see any prior conversations with Ms. Becker and our client, Ms. Becker, as well as Alex Cifuentes. Those are lost, and those you will never be able to see. We don't even know if these text messages are authentic because we have not seen the physical evidence. Ladies and gentlemen, that is convenience. That is doubt. You must remember that. Then we go to Kyle Kuzak, who testified that Avery Becker was the same height and build as the defendant, yet they had 3 alternative suspects, Alex Cifuentes and Blair Rollins. Alex Cifuentes' name was spelled wrong. If this was a thorough investigation, wouldn't typos be fixed? Then we look at Blair Rollins, who Kyle Kuzak even testified to, was the same height and build as the person in the Ring video cameras. That Blair Rollins was also missing at the time and is still unaccounted for today. That is doubt. Then Jordan Markowitz testified today that he had cell detail records of my client's phone. On the stand, she testified that a phone record cannot pinpoint someone's location. Just because a cell phone is somewhere does not mean that the person is with their cell phone. That is doubt. Everything today that the prosecution has brought to you was based on convenience rather than what is right or true. Let's go over the true events of what really happened. Before the events on March 6, 2020 and March 5th of 2020, Avery Becker, as she testified on the stand, did not have the best relationship with her coach. They often disagreed, but that doesn't necessarily mean that someone would go and commit burglary or murder to get back at them. According to Taylor Perkins and Avery Becker on March 5th of 2020, they were together at the Fry Shack together with none other than Alex Cifuentes. That was the last place Avery Becker saw her cell phone that is still missing to this day. She never found it, and the last place it was found was at the Fry Shack, next to none other than Alex Cifuentes. Alex Cifuentes could have easily taken that phone and placed it closer to Mackenzie Brockman's residence. That is doubt. Then we need to look at what of the events on March 6th. On March 6th, Taylor Perkins and Avery Becker were together at the mall and the Fresh Shack the entire day, from the beginning of school to the end of mock trial practice. That does not account with what the narrative that the prosecution wants you to believe. That is doubt. Then we have to look at Professor Blake Van Owen's investigation of the police procedure. We looked that these cell phone towers could have been anywhere in a 6-mile radius. Doubt. We can see that photos were corrupted, conveniently corrupted. That is doubt. Everything in this investigation was convenient and rushed. And all of it is reasonable doubt. Ladies and gentlemen of the jury, today as the defense, we bear no burden of proof. That relies upon the prosecution. They have to prove to you every single aspect of the charges today. And they have failed. For reference, let's look at jury instruction number 7 and 8, referring to aspect number 2. Today, the prosecution has not once mentioned where Mackenzie Brockman's residence was. Mackenzie Brockman's residence could be down the street, across town, or in another state miles away. They have not proven any location of where this could have happened. We don't know where Mackenzie Brockman's residence is, and that is reasonable doubt. Based on that aspect alone, you must rule not guilty of Avery Becker's crimes. You must find Avery Becker not guilty based on that aspect alone. But in coordinating with everything that is convenient, you must ignore the convenience and look at all the evidence of what is true and what is right. Find Avery Becker not guilty of first-degree murder and second-degree burglary, because what is right is often forgotten by what is convenient. Thank you.
Thank you, counsel. Does the prosecution wish to rebut the defense closing argument?
Yes, Your Honor.
You may proceed.
The defense will have you believe that the prosecution did what was convenient, not right. But you need to look at the evidence. You need to look at the facts behind this case that point to Avery Becker as the only reasonable suspect. The experts here today have proven that Avery Becker was in the area. They have proven that she had motive. Their theory hinges on Blair Rowlands, who they themselves could not locate. Avery Becker is here today because she is guilty. We ask that you find the defendant guilty because she is, because the facts point to it. Thank you.
Thank you, counsel. Can our Zoom manager please unmute our other panelists, and you'll let me know when you've submitted your ballots. And Mr. Downey, as is consistent with my entire day, that I'm getting error processing entry, internal server error message. What would you have me do with that?
Is that on your score sheet?
Yes, sir.
Is it filled out that you can see?
Yes, sir.
Is there
I've
any
got
way,
scores.
is there any way to print that document or save it?
I'm sure. Yeah.
And then you could maybe email it to me.
It will not surprise you to know that I don't have a scanner.
Okay.
Let's see if I can save it. Okay, I can save it and email it from my computer. There we go.
Okay.
All right.
I got Mr. Warner's submitted, and let me see here. Okay. Okay. Mr. Harwood, can you hear me?
Yes, I can. I had to get to my mute button.
Okay. Have you submitted?
I have not yet. I'm just finishing up with
That's
this
fine.
book.
Take your time. I want to remind the panelists to keep their comments brief here shortly when they do that.
Oh, sorry. I can see it on my screen, but when I opened the document that I emailed you to make sure that you got a filled out ballot, it is not. Double check what you received.
Okay, I'm doing that now. Yeah, it doesn't show me anything.
Yeah, it's strange because I'm holding in my hand a filled out ballot.
Do you have a cell phone? Can you take a picture of it and?
Oh, well, yeah.
And email the
Do you
photos
just,
to me or text
yeah,
them to
I
me?
can do that. That I can do. Okay.
Okay. I just received Mr. Harwood's ballot filled out.
It printed in 3 pages, so that is what I'm texting you.
Okay.
Excuse me.
I apologize. It looks like you had a couple issues along the way with people not getting admitted and with your chat. I was able to get
Well,
the
we
chat.
had just a technical error. I gotta tell you, Mr. Downey, these students are rock stars. They did not let technical difficulties get in their way. We had one student who, I don't know how she did it, swapped out a computer in the middle of this. We had one student whose computer system completely went down, and that's the one we had to readmit as he was getting himself back admitted. They showed far more composure with this technology than their judge did.
Well, I have your 3 pages of score sheet and I can read them. So, and I have Mr. Warner's and Mr. Harwood's. So I think we're good. And everything looks to be filled out completely. So with that, I'll let you go deliver your comments to everybody. You shouldn't have any problems with anybody that's speaking, but I will remain here in case there are any issues. So.
Oh, go ahead, Mr. Warner.
So I really enjoyed that. I thought you all did a really nice job with problem. I thought it was a fun problem to do. I hope you enjoyed it too. I echo what the judge said. It just seemed like you guys were dealing with all this COVID issues and everything else really, really well. Doing it on Zoom is probably not the way you'd like to be doing it. So, you know, congratulations to all of you for getting that done. And I thought you were all very poised. I thought you all did a great job. It was really hard to score because there was just some subtle little differences here or there with how you handled things. I really think that you're all, if you want to do this kind of work someday, on your way to getting there. So keep up the good work. I hope you guys keep that same energy for the next round, et cetera. You did a really good job.
Mr. Harwood?
Thank you very much. And I would also echo the judges and Mr. Warner's comments about the handling of a Zoom trial like this. Zoom is a wonderful technology, but to have a trial where people are not seeing each other face to face, when they're not hearing each other, is just an amazing job for everybody, I think, who participated in this. I think the nervousness has got to be doubled because of a Zoom meeting like this, because everybody is separate and isolated. I would congratulate all of you for not only the participation in the moot trial, but also the performance. I think you were all very poised. The first round of a moot trial is always difficult because people have memorized their talks, they have memorized their questions and answers. Some have done a better job, obviously, than others with that. And I think before the second round, people will practice a little bit more, and particularly in the inflections of the voices, because sometimes the answers and sometimes the questions are so well memorized that you forget that it's almost a conversation with a jury. And particularly some of the witnesses were excellent with that. It sounded like they were coming right off the cuff with their answer. They knew the answer, it was not memorized. But there are, I think people will see some of the scoring, so I won't go into the names, but some of the attorneys and some of the witnesses were outstanding, I think. And again, congratulations to you all.
I would echo our scoring panelists exactly. You all were phenomenal. The composure, the professionalism, the preparedness that you all showed. You have a lot to be proud of in your first time with us on this kind of a Zoom event. So thank you so much for your patience and instruction. Just a couple of just technical things. We saw some really good objections. I award points for good objections and argument. I thought that best evidence rule was pretty clever. If somebody's trying to prove that the statement, bring in the original. I thought that was good. Counsel wants to remember one way to respond to a hearsay objection when you're seeking to admit the defendant's own testimony. That's not hearsay. Just look at 801D2 and familiarize yourself with that. Don't be so quick to give up on having an expert qualified. I think you all had some good reasons, both sides, to argue why the proposed expert, as you would pointed out in your voir dire, maybe did not meet the expert qualifications. But those were just a couple of technical points, along with everything else that our expert panelists have suggested that I know you will all improve dramatically, as I hope to, with our next round. And best of luck to you all and to your coaches, family, everyone who's been supporting you, watching and applauding you from afar. You want to make sure you thank them for all of their support. I wasn't given any other instructions. A round of applause for everyone, other than we just thank and excuse everyone.
This is Jason. Yeah, you're correct. You're all
there
free
you
to
go.
leave.
Okay, thank you, everybody.
Thank you.
Be well.
Thank you very much for your time, Your Honor, and the jury.
Thank you for judging our round and for scoring.
Yes, indeed. Thank you so much.
All right, you guys are great. Good luck. Look forward to the rest of this tournament. Take care.